what this government's about.
Split call. Raymond Ho, 5 minutes.
Yes, indeed. Well, in light of the excellent speeches delivered by my colleagues, I will only need 5 minutes to unleash my reasoning and anger to oppose to this bill. As a member of the Local Government and Environment Select Committee, I had the privilege of hearing the submissions, not only in Parliament, but also in Auckland, Christchurch, and other regions when the Select Committee had special sessions there. Meeting with those local government representatives and listening to their submissions are very rewarding. Submissions from those 518 or so individuals, organizations, and local authorities are thoughtful, responsible, and constructive. The vast majority of the submissions opposed this bill. I should say this National and ACT government is very brave in ignoring those submissions and rejecting proposals to introduce sensible amendments. As the Honourable Annette King has emphasised, that Labour stands for effective and efficient local government. We believe in local democracy, local empowerment, and local choice. Labour opposes the Local Government Act 2002 Amendment Bill on 6 major grounds. First of all, we agree to the vast majority of the submissions and oppose strongly the changes to the purpose of local government in the Principal Act. The 4 well-beings, namely the economic, social, cultural and environment well-beings, are what local is all about.
Which is most important?
We agree, yes indeed, Mr. Simon Bridges, we agree to the Auckland District Law Society that the new purpose statement, which is narrow and more restrictive, will cause legal confusion and uncertainty and risks legal challenges to council decisions. Secondly, the bill is based on misinformation and a very small number of examples, particularly in relation to rate increase and debt levels of councils between 2002 and 2011. For the information of Mr. Simon O'Connell, who touched upon the issue of rate increase, I can tell him that rate increases, for example, for Tasman District and other councils, are more the result of, well, I cited as example. As I said, I had the privilege of hearing the submissions not only in Auckland but also in South Island as well. Are more the result of the provision of infrastructure, addressing historical deferred maintenance, and additional regulatory responsibility imposed on councils by that member's central government than a result of the purpose of local government in the Principal Act. Thirdly, the bill has been rushed, written before sufficient evidence has been gathered to support the changes. And fourthly, the so-called better local government, or Dr. Nick Smith's approach, or the so-called reform proposals are being implemented in the back-to-front way, with a number of reviews aimed at gathering evidence, information, and providing advice are due to be reported after the passage of this bill. And further, the reorganisation proposals for local government are anti-democratic, with the removal of an automatic poll of voters in an affected area. And the bill leads to far greater interference in local government by the Minister of Local Government than is warranted by evidence. Currently, the law guarantees to all citizens the right to a say in the binding ballot of any proposed reorganisation or amalgamations of their local council. This bill takes away that right. It is the confiscation of the democratic rights of New Zealanders.
Denise Roche.
Thank you, Mr. Speaker. Ngā mihi nui ki a koe me tēnā koe ki te whare tēnei. I'd like to start my